Greetings, dear colleagues, candidates, and the public. Today, on January 19 of 2025, the advisory group of experts has gathered in full composition to conduct an interview with a candidate for the position of the judge of the Constitutional Court of Ukraine, Mr. Melnychuk Anatolii Anatolievich. At the meeting of the AGE, all 6 members of the AGE are present. Secretary of the AGE, Madam Maureen O'Connor, Member of the AGE, Madam Hanna Suhodska, members of the AGE, Mr. Vasil Shakun, Mr. Yaroslav Romanyuk, Mr. Aleš Zalar, and I, Chair of the AGE, Oksana Vasilchenko. Deputy members of the AGE are also present at the interview, Mr. Volodymyr Kuzmenko, Mr. Marek Zubik, Mr. Vitaly Makhinchuk. I would like to point out that we are working in a shelter, so in case of an air raid alarm, the interview will continue without interruption. I would also like to remind you that the interview is being recorded and broadcast live at resources of the AGE and at the website of the Constitutional Court of Ukraine. I would like to draw attention of the AGE members and of the candidates regarding restriction of the use of sensitive data and information with limited access. In case it is necessary to discuss such issues, the broadcast will be suspended. So, we are ready to start. So, I'm passing the floor to the Secretary of the AGE, Madam Maureen O'Connor, for a short presentation of the candidate and reminder of the interview rules. Madam Maureen, please, the floor is yours.
Thank you, Madam Chair. Greeting colleagues and everyone who is watching this broadcast. And to our candidate. As our chair has already said, the advisory group of experts will now interview the candidate Anatolii Melnychuk. Let me remind you that the interview is a opportunity to the candidate to be interviewed by the advisory group of experts, and it is mandatory that we offer this to the candidates as part of assessing their compliance with the criterion of high moral qualities. The interview today will take approximately 1 hour, and the time limit for answering questions is no more than 3 minutes. Traditionally, we ask all candidates to be concise, to answer the questions posed clearly, unambiguously, and to the point. At the end of the interview, the candidate may make a short closing statement that is no more than 5 minutes. I would also like to note that during the processing of materials about our candidate, the AGE sent him questions for written explanations, so the candidate has had the opportunity to prepare and to provide answers. So now we have with us a candidate for the position of Judge of the Constitutional Court of Ukraine, Anatolii Melnychuk, who has been admitted to the competitive selection by the Competition Commission under the President of Ukraine. He is an attorney with over 17 years of practice experience. He has also worked in internal affairs bodies and prosecutors' offices, in particular as a senior investigator in particularly important cases of the main investigative department of the Prosecutor General's Office of Ukraine. Mr. Melnychuk, if there's anything you would like to add to your introduction that I have neglected to mention, you may do so now with up to 3 minutes.
Thank you. Nothing to add.
Okay, great. Thank you.
Then let's start our interview. Mr. Aleš, the floor is yours.
Thank you, Oksana. Good afternoon, Mr. Melnychuk. I will start with a question regarding the absence of declared income from your practicing of law. According to the extract from the Unified Register of Advocates of Ukraine, you have been practicing individual advocacy since 2007. In your response to the question of the advisory group of experts, you indicated that in the year 2023, you did not receive any income from practicing advocacy and accordingly did not pay income tax. At the same time, as you noted from the documents that have been reserved and that were provided by you, in the period from 2015 to 2021, you paid a single social contribution, which was mandatory for payment. In addition, you provided tax declarations on property status and income for a period 2013-2020, and a certificate or registration of taxpayers dated for a year 2012. So how you can explain the absence of declared income from practicing law in the tax returns on property and income, as well as in the declarations in the candidate for the position for 2023 and 2017?
Thank you for your question. In November 2007, I got the attorney's license. In 2008, I started practicing my law activity, and up until 2010, even part of 2011, I was registered as the individual entrepreneur with provision of the legal services. At that period, I was on the single social contribution, and I paid the amount specified by the law at that time. In 2010, I stopped my activity as an individual entrepreneur because certain circumstances have changed. So I had less clients, and I decided to do to practice law individually. And I have submitted all these documents to the tax authority and ceased activity. In 2014, my activity was seized. Next, I did individual advocacy up until now, and I don't have many cases. And I am providing legal services to the persons indicated in my answer during one round of questions. On agreement with clients, since at that time I worked in different ways, I mean payment wise. As of 2008 until 2010, I did legal activity, and the payment was when I only began the case and only on the completion of the case. There were instances when the clients stopped cooperating with the lawyer and they tried to defend themselves another way and to prove them unguilty in another way. So the question was about returning certain amount that from which we would only calculate the funds that were actually spent on the legal aid. Next, I did have some complex cases, and I mainly work on criminal proceedings. There were some difficult, challenging cases, and there were questions when people give you money in advance, like make an advance payment, or they would refuse on certain reasons, but this money had to be stored somewhere, because my principle is the following: I did the job, so I get the salary. I didn't do the job, so I can also include the factual expenditures, and I have to explain to the person, and they are to decide whether or not they're ready to give that amount. So we would agree on the amount in advance. As of 2018 up until now, and I made my references in my answers, I have such categories of cases that are ongoing as of 2012, so for many years. And this does not depend upon me or my client, but from the position of the prosecution office and the courts. And there are different reasons. These cases either are postponed or something else. So we had the agreement with the clients that they would pay me the income for the provision of legal aid when the criminal proceeding is closed. So as of 2013, 2015, until now, I have no income from practicing law. That's why I did not submit the declaration on tax on income. But as for the single social contribution, it's something that is mandatory, and I did pay it, and I did show it in my declaration.
How come that so many years you have no income, and how you can survive this? I mean, what kind of sources do you use to live, to pay normal daily expenses?
Thank you for your question. First of all, I have my savings, joint savings, the savings of me and my wife, and also I also work in the prosecution bodies where I got a good pension, and it's enough for me. It was enough for me to provide for my living and for my family and have a decent life.
Stated in your written responses to the advisory group of experts questions from the period 2013 to 2023, so in that period of 10 years, you provided legal assistance to at least 10 individuals, 2 of whom, as you noted, were provided free of charge. At the same time, you did not provide supporting documents regarding the provision of legal assistance to these individuals, citing the fact that your clients prohibited you from transferring any documents containing their personal data to third parties. Did you receive income from providing legal assistance to these individuals?
Thank you for your question. From the persons that I indicated in my answers, I didn't get money for the legal assistance, and I explained why. I have nothing else to add. As for the documents, the supporting documents, I have indicated on, for example, first instance in which court the case was considered. If I couldn't do this without permission of one and second person to provide the documents that I had in my proceeding. But I showed where these cases were, in which courts, and in which prosecution, who was the decision maker. So I basically specified that you can contact them to get certain answers.
Our task. This is your task because you are a candidate and you have to clarify everything what might be considered as a doubt from the perspective of high moral qualities. So again, you claim still that you have not received any income from those clients, regardless the fact that you did not provide free of charge service.
Yes, I did not get any money from these persons, and I could only make this information I could only disclose this information if from their permission. And also, I would like to draw your attention that with other persons that I worked with and that I indicated in my answers, their names, last names, and criminal proceedings were provided to the AGE with their permission. That's why I have described them. And this person refused to provide any information to third parties. That's why I did this. That's why I acted in this way.
Group of experts has information on 15 copies of contracts for the provision of legal assistance by you. And these are 2 contracts for 2013, 4 contracts for 2014, 2 contracts for 2015, 6 contracts for 2016, and 1 for the year 2017. In all cases, in accordance with the terms of the contract, the amount of the fee was determined by agreement of the parties with an 80% advance payment and a possible payment of bonus funds in the event of a case being resolved in favor of the client. It should be noted that in your autobiography, you also indicated that in the year 2021 and 2023, your client receives acquittals in a number of district court. Given the fact of declared income from practicing law in the period from 2013 to 2023, how can you explain this situation?
Thank you for your question. On account of the acquittals, yes, indeed, in 2021 and 2023, I think there were two acquittals, but at the moment these acquittals are under consideration in the appellate institution on the because of the consideration of the complaint by the prosecution. The agreement with my clients on pay of the bonus, it was agreed that I would get this bonus at the end of consideration of the case and when the court decision is valid. The decision of the court comes into force under consideration by the courts of appeal, but we had one instance on one case when the acquittal was in 2021. The appellate made it valid, but the cassation institution has abolished the decision of the courts of appeal, and today it is still under consideration in the courts of appeal. So these two cases, they have not been completed, so I do not claim or I do not count on the money that should be paid to me by the clients. And also I would like to add that in my written answers I have indicated other cases where I cannot also demand the honorarium from the clients, and the reason for that is that now currently, and I don't know how much more time, for how long more, these cases will be under consideration of the district courts of Kyiv City, Kyiv region, and also Chernihiv region. Even if they pay me, they only pay for the actual expenditures that are related to the transportation. So when I have to go to the place of consideration of the case and going back to the place of residence. And they can also sometimes can buy me a cup of coffee. That's all.
This doesn't sound very realistic, because on one side you say I have no income from that time. On the other side, we have contracts in which it's clearly stated that the parties should pay 80% advance payment. Where is this 80% of advance payment?
Thank you for your question. On account of 50% or 80% or 20%, it's the form of agreement that hasn't changed for some time, but in fact, and the real situation is that out of all those cases that I practice my legal activity, providing the legal assistance to these persons, I didn't get any pay from these clients. That's why I didn't indicate them as income in my declarations.
What have you done in order to get the pay? Have you sent a letter, a warning letter to the clients? What steps you took in order to get 80% of bonus, not bonus, the advance payment?
Thank you for your question. So one more time, I would like to say that I did not get such payments from persons with whom I have concluded agreements. This is just a standard agreement that was initiated in the beginning of 2000. So first it was 50-50 payment, like 50 is the prepayment and 50 at the completion of work. Since you could see the attitude of the clients and how they would be settling. And then there was a 20 to 80%. And then during concluding agreement, it was just a formal thing. I mean, it's a mistake that I didn't pay attention to. And on account of whether or not they will pay me, we had clear agreements with these clients, and it was agreed that the payment of the honorarium will be done at the end of consideration of their case.
Constitutional Court judge of Ukraine, and somebody tells you that there are 15 contracts, all concluded in the long period from 2013, 2017, and in all cases, is the same clause about 80% advance payment, and in all cases, the parties didn't pay you. Do you consider this as a convincing explanation? Imagine that you would be a judge now.
Дякую за
Thank you for your question. Well, since you already called me that way, I am no judge of the CCU now. And if I am selected as the judge of the CCU, I will adhere to all requirements of legislation. And also, the judge of the CCU cannot conclude any agreements with clients or provide them some sort of legal assistance. Therefore, I think that right now, at this moment, I have this type of agreement with my clients, and I can only show this income only after I get my honorarium for the cases in which I am providing them services.
It's actually your decision. You are here to clarify the doubts, and the ADE has a serious doubts as to whether you received no income in such a long period of time while practicing law. This is not normal situation, and we wanted to clarify this doubt. And we will continue now with the questions. So my next question to you is, in your written response to the question of the advisory group of experts, you noted that in December 2007, your wife, Tatiana Ivanivna Melnychuk, became a member of a limited liability company, PBK, Kiev Budmontaj, the members of which, from the moment of registration of that company, included citizens of Russian Federation. What do you know about your wife's participation in the activities of this company?
Thank you for your question. So, as for the activity of this company, I have provided the answers and the supporting documents, the copies of the supporting documents that we had, because we do not have the originals. I have provided them to the advisory group of experts, and there you can clearly see the problems and the application. I also provide the first pages with marks of the Commercial Court of Ukraine, where she has claimed to get the monetary assistance, but these decisions were not made, cases were not considered, and in fact this began in the mid of 2008, the conflict between the founder of the company, and it ended also in 2008, but the measures to quit the composition, to exit, we checked the legislation back then, and you had to file a claim to court, and we even sent the letter to one of the founders who had the but he lives in Moscow, and there is no formal confirmation whether or not he received it. In 2024, when in legislation, I cannot even remember, I think it was 2017 or 2018, the procedure for the founders to quit the LLC was updated, and we used that right, and my wife managed to quit this enterprise. Today she is no founder of this enterprise.
Yeah, but why did your wife file an application with the registrar and withdraw from the membership from LLC only on August 20th, 2024? Could she have taken appropriate actions earlier, given the circumstances you explained, or this is just because you are a candidate for the Constitutional Court?
Thank you for your question. No, this is not related to participation in the competition for the position of the judge of the CCU. She could and she tried to do everything possible to leave this LLC earlier, but since mid 2008 and until the period of time when she filed an application with the registrar, she did not take any part in activities in control of this LLC. So that is why there was to take some ways and to go to court and to cancel that her participation in founders. She did not have the need to do that, so she did not decide to do that. Once the simplified procedure for exiting founders appeared, she used this right, but it was not related at all to my participation in the competition for the position of the judge of the Constitutional Court.
Yes, and obviously was also not relation to the Russian aggression to the Ukraine, which started much earlier. So in the declaration of yours for the position of disciplinary inspector of the Disciplinary Inspector Service of the High Council of Justice for 2023, which was submitted on January 2024, you indicated the presence of your wife's share in this company, LLC, BBK, Kiev Budomontaj, with a monetary value of a little bit more than 15,000 Ukrainian hryvnias. In the declaration for the position of judge of the Constitutional Court of Ukraine for 2023, submitted on September 1st, 2024, you no longer reflected the relevant information. Please explain why the relevant information was not reflected in your declaration for the position of a judge of the Constitutional Court of Ukraine for 2023, submitted on September 1st, 2024.
Дякую.
Thank you for your question. As of January of 2023, she was one of the founders, and she was listed as a participant of this LLC in August of 2024. When she found out, and when we together found out about this simplified procedure for exiting the founders, she filed an application to the state registrar, and she was removed from the composition of founders without the right to claim that amount of funds which she invested during the establishment of this LLC. Accordingly, in the declaration dated in the declaration for participation in the competition for the position of the judge of the CCU, I did not reflect that because she was no longer the participant of this LLC.
Я надав
And I've provided supporting documents.
Today, are you or your spouse aware of any information about the continued active business activities of this company and its participants in the territory of Ukraine or outside its borders, in particular in the territory of the Russian Federation? Was any such information also known to you and your spouse in the period from 2014 to 2024?
Дякую за запитання.
Thank you for your question. Neither I nor my wife, during the period from mid 2008 until nowadays, have known any information. We do not know whether this LLC performs any activities, whether persons who are its founders perform any activities, or who remain founders of this LLC on the territory of Ukraine or Russia. We do not know about this. We do not keep in touch with them, and we have not done that since 2008 at all. So we do not have their phone numbers, addresses. We do not know where they reside nowadays. We have no information about that.
Thank you for your answers, and I will pass the floor to my colleague, member of the advisory group, Mr. Vasil Shakun. He will continue.
Дякую.
Thank you. Let's continue. In the declarations of the candidate for the position for 2023, you indicated that your wife has a 50% share in the authorized capital of LLC law firm Zuber. According to data obtained from open sources, it became known that LLC law firm Zuber was founded in 2008. Founders of the company in equal shares were your wife and Bohutska Bogdana Petrivna. At the same time, in open sources, there is no information about your legal practice of your wife. Besides, from the information obtained from open sources, it is clear that your wife is a practicing psychologist and positions herself as a person who has, I'm quoting now, over 20 years of experience in psychological support, diagnostics, and analysis of the psychological condition of children and adolescents. So, does your wife have a legal education? Thank you for your question. Yes, she does. She graduated, I cannot name the year specifically because we missed this moment. She has two educations. The first one is a bachelor, which she graduated from Rivne Agrarian College. Further on, she graduated and obtained higher education from the Academy of the Federation of Trade Unions in Kiev. So she has a diploma, and I have provided the answer to this question. I have provided the copy of this diploma to the answers that I've provided. So, as of the moment of founding the law firm, she already had this legal education. That is the education that she received in Rivne Agrarian College. In 2009, 2010, or it may be 2008, I think it was related, first of all, to the fact that she worked in the Center on Adoption at the Ministry of Education. Due to liquidation of this center, she was at the unemployment center, and she was thinking what to do next. Simultaneously, since she was dealing with issues concerning children, and she had this education of a psychologist, she was writing the candidate's dissertation where in the Institute of Psychology where that she works now, and she wanted to try her efforts in legal sciences as well. It's obvious that she has lived together with me since 1990, and at the adoption center she was also dealing with legal issues. I've provided in my answers and have drawn your attention to that. So, as of the moment of founding this law firm, she had legal education. As far as I understand, she wanted to practice law. But for now, we do not see this information. If you do not have this information about your participation in during work with clients, what can we talk about? Tell about your wife. What legal practice does she have? Back then, as of the moment when she was the founder and when she worked in this law firm as well, in this LLC law firm Zuber. She worked there as a director. She hired lawyers, and they had requests from clients to whom they provided legal services. Officially show Well, I think in 2017 this company applied for termination of its activities, and she submitted all required documents to the tax inspection in order to confirm its activities and close it. These documents include respective agreements and contracts with clients, and they provided legal aid. Besides, I also was involved and I provided legal aid. So the company involved me into some cases. We concluded agreements. Accordingly, I received funds from this company for provision of legal aid to those persons with whom contracts were concluded, and that is reflected in the register on income, as far as I remember, for the period of 2008, 2009, 2010. Let's continue the discussion of this firm Zubr. Another co-owner of this LLC is Bohutska Bogdana Petrivna. At the same time, from open sources, we have such information that Bohutska Bogdana Petrivna is a teacher of chemistry. In view of this, do you know whether Bohutska Bogdana Petrivna has legal education and has she practiced law? And what was your role in the activities of this law firm? Thank you for your question. I would like to draw your attention that not my company. The founders, my wife was a founder of this law firm, and Bohutska was a co-founder. My wife worked as the director, and only if necessary I was involved. Following the procedure of civil legal relationships, I concluded contracts and paid taxes, and they also paid taxes. With respect to Bohutska, back then and nowadays I have provided answers. I do not know whether she had or has legal education. And I pointed out that citizens of Ukraine do not need to have this education if they are founders of LLC or some other enterprise. It is not mandatory to have this specialty, which will be the main direction of the company's work. That was their right, that was their arrangement. They together. Bohutska, maybe you will ask this question later on, that is wife of Yuri Matyovka. We have been friends since 1997 until now. And yes, we used to work in the prosecutor's office together with Matyovka. Our wives have been friends, and back then they had this desire and they did that. Okay, clear. We could believe in what you are saying, but there is only one question. Why then the documents regarding registration of this company specified your phone number, not your wife's phone number? Thank you for your question. I have provided explanations regarding this. I received the attorney's license in 2007, in November. The registration of this not company, the registration of this LLC took place in December of 2007 and ended in 2008. I was dealing with this issue. Why? Because first of all, I was looking for the direction to work in. The issues of registration of the LLC, you did not need legal education for that. So maybe this phone number stayed with the registration bodies because I was registering this LLC, so they kept this phone number. Yes, I received calls. I immediately provided the phone number of the director of this LLC, and accordingly it was the situation. Since you've confirmed that Matyovka is your friend and his wife is Bohutska, don't you think that from the perspective of an outside observer, the above circumstances regarding activities of this LLC law firm Zubr may appear to indicate that you, together with your friend, created this company and registered it in the names of your wives. Thank you for your question. No, I have provided the answer to this question as well, and I would like to say that persons who came to the law firm has never had this question, and I lived with my wife all the time, and of course my wife would have shared that with me, and there were no instances when Yuri or his wife said that they were addressed by people who connected us with our former job. Back then, I and Yuri did not work in the prosecutor's office anymore. So I think that if there had been such instances, then everyone would have known about that. But there were no instances like that. We were all doing our job. So I don't think that an external observer could have any suspicions about that. For now, let's talk about some errors and discrepancies in your submitted declarations. In particular, in your declarations for 2023, you indicated that you had your own cash funds in the amount of $152,000. At the same time, in the declaration of the candidate for the position for 2017, you did not specify any information about monetary assets, in particular availability of cash funds, the amount and currency of the assets. Can you please explain how your cash savings were formed? Thank you for your question. I have provided explanations regarding this because this has been the priority question in questions to me. These were our joint savings together with my wife, which were formed since 1990 and until nowadays. With respect to the declaration, why it was not reflected in the declaration submitted in 2017 and why I submitted this declaration. I've also provided explanations and I have provided supporting documents about the reasons why I did not specify information about our savings. I would like to say our savings. I cannot say that these were my personal savings. In responses, I have provided copies of documents about 2 criminal proceedings, as well as references to internet publications where it was specified why I did not declare this information in 2017. In 2023, I believed, so to say, and there was consent of my wife, of my family, that we, neither I nor my wife, treat everything fairly all the time and with integrity. And I would like to say that it was decided, after all, to show them. But who can guarantee to our family in case of some instances? I mean, I have provided you with documents which confirmed the theft, the burglary at the cottage house, breakdown into the vehicle, even though there were possibilities, and I provided this information to them, how to identify those persons who did that, but cases were not investigated, are not investigated. So nowadays it was decided to declare our savings, and accordingly we did that, which actual savings we had. That is as of the moment of submission of declaration. If you think that this information is confidential, we can close the broadcast for some time. If you want to, if you're concerned about that. You mean these instances, savings? Savings, yes, please. No, you should say. Okay, thank you. In my answers, I have provided supporting documents about sources of information of these savings, and I have provided these documents. And if we even based on the table that I have filled in for each year since 2003 to 2023, then the difference between those savings and the difference regarding those expenses, there you can see the remaining funds as of 2024. I've summarized and I've checked that in summary. Again, another question about the declaration. In your annual declaration of the prosecutor of the department for 2017, which is publicly available, your son, Melnychuk Vadim Anatolievich, reflected information about his income and sources of origin of this income, and also pointed out existence of cash funds in the amount of $5,000, which were jointly owned by your son and his wife. At the same time, your declaration for 2017 did not reflect any information about your son's income and sources of this income or his monetary assets. Please explain what is the reason for this discrepancy between your declaration and the declaration of your son.
Thank you. My son has his own family. They don't live with us. They have their separate family life together with his wife. What he declares, I don't know, and I don't check, and he doesn't report to me. And why it hasn't been reflected, well, I did know that I had to reflect information also about my I don't know, relatives who don't reside together with me. I have reflected the income and property of those people who live together with me in the apartment where I am registered and they are registered. So that's the way it is. That's one part. Let's now proceed to another part. Maybe of not very significant but very systemic violations during filling out the declaration. Your declarations as a candidate for the 2017 and 2023, there are also many discrepancies and errors, including your declaration for 2017 does not reflect any information about your mother-in-law income and sources of this income, her monetary assets and real estate objects. For 2023, no information about your daughter's income and sources of this income. The three declarations reflect different information about the value of the car owned by your wife. Your membership in the National Bar Association of Ukraine is not reflected. You also indicated yourself as the source of income in terms of pension payments and not the pension fund of Ukraine. You did not reflect information about the right to use real estate objects by your daughter, despite the fact that she was abroad during 2023 for about 236 days. You did not reflect any information about your wife's income from leasing a land plot to business entities. And the list can go on, actually. Could you please explain? Thank you for your question. You are the lawyer, so. And as a former employee of the prosecution office, I guess you should have some scrupulous. You should have had a scrupulous attitude to such documents. You also used to be an investigator. Well, then, as an investigator, know that any mistake is the reason for additional doubts. Yes. Thank you for your question. Indeed, mistakes were made. Given the questions that I got from the AGE, I admit these mistakes, errors. One thing I can say is that I did not read the law on corruption prevention properly, and maybe I didn't understand it properly. I mean, the explanations to each of the items of the declaration. I admit this. All those questions that you just asked, I also received them during the first, second, and third rounds, and I have provided the supporting documents. I have corrected these mistakes, and I try to answer all of the questions that I received. I do admit it's true, these are discrepancies. Your declarations for 2023, no information about bank and other financial institutions is reflected, in which you or your family members have opened accounts or store funds or other property. However, later in your answers to questions of the AGE, you provided relevant information about bank accounts. Given the above, please explain why your declarations for 2023 do not reflect any information about your bank accounts and bank accounts of your family members, as well as the funds placed on them. Thank you for your question. I also provided the explanations on this account, and I would like to remind again the reason for non-submission of information about bank accounts was related to the will of my family members. That's on the declaration for 2023, in September 2023. And not only in September, but also in the beginning of 2023. And then we just sat and talked. I explained this necessity is there, and my family members provided me the details, bank details, where they have bank accounts. But as for the question concerning the amounts on these accounts, the remaining amounts or the balances of their accounts, we provided in the table. But as for my daughter, she said no, because she said that she had concluded an agreement with the employer, and one of the clauses on the information that she's making, the clear amount is specified in the agreement, but what amount it is that is transferred to her bank account, she said that this information is, well, not confidential, but some like personal data, and she refused to tell the balance on her account. As for accounts in which banks, this information was provided to in answers to one of the questions. I see. Let's continue then. According to an extract from the Unified Register of Advocates of Ukraine, you have been practicing individual advocacy since 2007 at the address in Rivne region, the address of residence of your mother-in-law, Kovalchuk Svetlana Kirillivna. As you indicated, every 2 years you conclude a loan agreement with your mother-in-law for the free use of residential premises at the specified address and provided relevant copies of documents. Please explain why the relevant information was not reflected in your declarations earlier. Thank you. This was my mistake. I think I read the law on corruption prevention with little attention, and as well as the explanations provided for each of the chapters of the declaration. But I have confirmed the facts of concluding loan agreements, and that my main place of work is indicated in the profile, I mean in the register of advocates of Ukraine. So and that is the place of registration of my mother-in-law, and I am the member of the Unified Register of Advocates of Ukraine, and also in Rivne region. And since I could provide not less than 2 addresses, one main address and second workplace address, the decision was made, and I did provide the explanations also, that it is sufficient to have one address which you find as the main address. I'm not, spending all my time at that address, and the law about the um, legal activity do not demand to stay at the address that is specified in the register. In this register, there are 2 phone numbers specified, the email address, and those persons who want to contact you, they can send questions either via email or they can phone up, so they can dial your phone number. So indeed, I admit that there were certain mistakes, but I don't think that it's a violation. And currently, I am providing legal services not only in Rivne region, even though as of 2008 until 2010, I most of the time stayed in Rivne region. So I decided to leave this address of my mother-in-law. Currently, my workplace is the apartment where I'm registered, and my house, the house where I cannot register, but it's a townhouse where I live. And all conditions to provide legal assistance and to prepare for cases I have there. So I can be both staying on this place of registration and on the address where my townhouse is located, or detached house. I see. So what is your opinion? Do you think the outside observer who are observing our communication, do you think they may have an opinion that you consciously for a very long period of time freely interpret the law and sometimes even violate it? Maybe it's not of some critical significance, but it does create some negative aura around your candidacy for the position of the judge of the CCU. Thank you for your question. Well, I am no outside observer now, so I can't tell you exactly. I think it will be easier for the AGE to make the decision and to draw conclusions. I'm also not perfect, and I'm no saint. Each of us makes mistakes, but the mistakes are corrected in the future, and it's not systematic. It's not a systematic violation, and I did not have an evil intent. So it's because of unattentiveness, and when I am reminded of it, of course, I start to pay attention more and to read more carefully the law, and I analyze my mistakes and I try to refine them. And finally, I have one last question. Well, about your motivation to participate in the competition. Previously, you also participated in such competitions. For the position of judge of the Appellate Chamber of the High Anti-Corruption Court of Ukraine, competition for the position of head of the Disciplinary Inspector Service and his deputy, Disciplinary Inspector of the Disciplinary Inspector Service of the High Council of Justice, competition for the selection of candidates for administrative positions in the Specialized Anti-Corruption Prosecutor's Office. Please indicate what were the results of your participation in the relevant competitive procedure, and what is the reason for your interest and participation in so many competitions for various positions. And finally, what is your immediate motivation for participating in this competition for the position of the judge of the CCU? Thank you for your question. Each competition took place in different periods. I didn't say that they were held at the same time. No, I'm just explaining myself. So the driving force for me of why I participate is the judge of the Appellate Chamber of the High Anti-Corruption Court of Ukraine, the disciplinary inspector, This is, and they say the administrative position of the prosecutor in the Specialist Anti-Corruption Prosecutor's Office. So all of these were related or affiliated with my former position I held up until 2007. And that is the position of the senior investigator in especially important cases and in the general prosecution and in other law enforcement agencies. That's all due to the experience that I got during my work in these bodies, and also it is related with the experience that I got during my advocacy activity as of 2007 up until now. So I made decisions, and I thought that given the functional duties that were expected from like the judge or prosecutor or the disciplinary inspector, I thought that I could fulfill those, having that same experience and knowledge, and that I could fulfill my duties properly. Currently, I'm also I would like to also reference the gained experience and knowledge that I got during my work in the law enforcement system and the law practice. And I think that I'm able to contribute part of me to fulfill the functions of the judge of the CCU and to fulfill them conscientiously. That's why I made the decision to participate in this particular competition. And my last question, you said that you will aim your professional activity at cases related to criminal violations or offenses. Do you have some scientific papers, publications? No, I do not. I do not have publications, but maybe you participated in competitions, scientific competitions on the constitutional law, maybe, because this is one of the components, of the main components of the work of the judge of the CCU. So the deep knowledge of the constitutional law and the constitutional legislation, not only of Ukraine but also of EU. Thank you for your question. Indeed, I do not have practice of participating in some conferences or anything that refers to constitutional process and law. In my activity, having been working in the law enforcement system and exercising law practice, I am constantly defending rights and interests of the citizens that seek that support from me. And in my previous work, I also was defending our state from the criminal offenses. So I do not have like the exact such skills in the constitutional law, but I think that the experience and knowledge that I have, that they enable me to participate and to be selected to the CCU for the position of the judge. Thank you. Dear colleagues, are there any other questions for the candidate? Allow me, please, says Yaroslav Mikhailovich. Anatoly Anatolievich, for many years you have been working in the prosecution. And you were responsible for an important area, and also we learned that you were the investigator in case of the former Prime Minister Mr. Lazarenko, who was further on convicted by the USA court, and you were many times encouraged in the prosecution. Mainly in November, you got the reward as the honorable employee of the prosecution office. And due to this, I have a question. Why in June or August 2004, June 2004, you were dismissed from the prosecution office for the offense that undermines the reputation of the employee of the prosecution office? This was a long time ago, but still. having such a long list of good reputation, and then there's like misconduct that undermines the reputation. Thank you for your question. I have provided the answer to this question in much detail, but right now I would still like to be laconically tackle it. As of 1998 until 2000, I worked in the group of investigators investigating the criminal. Back then, these were criminal cases. The criminal case on Pavlo Lazarenko, Petro Kirichenko, and other persons, and these persons of the Cabinet of Ministers. So they are the ministers and other managers of the Cabinet of Ministers of Ukraine. And I had. I will not name them, not to have any issues, but in that case other episodes were investigated, but I was responsible for investigation of the episodes. Can we maybe stop live broadcast, because I will be giving names now and I don't want them to be in live broadcast. Hold on, please.
Please suspend the broadcast. Dear colleagues, do we have any other questions to the candidate? If there are no other questions, Mr. Anatoly, now you have the opportunity to address us with concluding remarks with up to 5 minutes. Thank you. After all, I would like to read because I'm a bit worried. Dear ladies and gentlemen, The co-author of the first constitution, Philip Orlik, said, it is a natural right to get rid of slavery and to return what was taken away from the first. 33 years ago, our state became independent and our nation became free in deciding on its will. In 1996, the Verkhovna Rada adopted the constitution and enacted it, which enshrines the legal principles of the independent Ukraine, which became an important step for ensuring human rights and citizens' rights. Right now, the Ukrainian people is paying the highest price for the defense of our independence and freedom because of the aggression of the Russian Federation, which is trying to overthrow the constitutional order and to destroy the Ukrainian statehood and the Ukrainian identity in general. Many of my relatives, friends, and acquaintances, just like many Ukrainians, are fighting for their independence with weapons in their arms and are trying to defend the territorial integrity of our state. Yes, having this age, I cannot be mobilized into the armed forces of Ukraine, but if necessary, I'm also ready to defend my country with weapons in my arms. And right now, I'm continue providing legal aid to the citizens and making charity contributions and donations to the benefit of the armed forces of Ukraine. I'm a practitioner. Being in the law enforcement bodies and now practicing law, I have always tried to follow moral principles and to follow the golden rule of morality. Do unto others as you would like them to do upon yourself. Have I committed any mistakes in my professional and everyday life? Yes, because as Irish philosopher Oscar Wilde said, you receive wisdom with experience, and experience comes from mistakes. If you made a mistake, look for ways to improve, and where you succeeded, try to replicate and achieve more success. Experience is gained when you encounter different situations and when you take decisions, and then you make conclusions based on outcomes. The 35th President of the US, John Kennedy, said, "Do not ask what your motherhood can do for yourself. Ask what you can do for your motherhood." I believe that my professional experience, including work in law enforcement bodies and the practice of law, will allow me to effectively fulfill duties of the judge of the Constitutional Court of Ukraine while ensuring independence, objectivity, and fairness of decisions, while remaining true and faithful to constitutional principles. I'm ready to undertake responsibility and to ensure fulfillment of duties delegated to the judge of the CCU. The key goal of my life is to contribute to the establishment of the democratic and free European Ukraine, so that our children and grandchildren would want to stay on their native lands. That is why I believe that it is my duty to apply my efforts to the formation of the Constitutional Court of Ukraine as the institution that is trying to defend human rights and citizens' rights, and that is trying to do everything possible for the people. Thank you for your attention, and have a lovely day. Thank you for your answers, Mr. Melnychuk. Dear colleagues and the public, I am hereby declaring interview with a candidate for the position of the judge of the CCU, Melnychuk Anatolii Anatolievich, as